You watch that defendant go directly to the houseware aisle in Volunteers of America, go through that bin, look at the knives, inspect them, handle them, look up top the knife block up there. She spent almost a minute looking through these knives. She doesn't pick the first one she sees. She finds the two favorites first, and then she walks out of the store. She made a decision. That was careful. We spent a lot of time on cross-examination with Dr. Noxton today about how Bianca Ellis didn't just stab anyone in the Volunteers of America store. Well, the next report are this is calculated. She walked out of that store and went to the store next door. Encounters more people on her path. And then when she gets to Giant Eagle, that's when she chooses her victim. But she knew when she chose those knives what she was going to do. She was going to harm someone. She was going to take somebody's life. Now, murder is charged with count 2 and 3, and they're charged under different sections. So count 2 is that Bianca Ellis did purposely cause the death of Julian Wood, and count 3 is that she caused his death as a proximate result of an underlying felony. And what we mean by that is that he died because she committed or attempted to commit felonious assault and or endangering children. And with these charges, there are degrees of culpability and mental state. Okay, so when we're talking about purposely, and again, you'll have all this in your instructions, but these are the definitions of purposely and knowingly. And we're talking about this defendant knowing that her actions would bring about a certain result. Okay, so we know that when she selects that butcher knife and she ultimately stabs 2 people with it, that she's going to bring about a result, right? She's going to hurt them, she's going to kill one of them. And you think about it, with a butcher knife, if you stab somebody, that's going to be the result. You harm or kill. Okay, so when you deliberate these counts, ladies and gentlemen, you can consult your instructions. I'm not going to go through these ad nauseum. Okay, I know that you are a smart, attentive jury, but I do want you to pay close attention to count 1 and talk a lot about that prior calculation and design and the plan that Bianca Ellis had that day. And of course, she had no relationship to these people, and that's okay for proving prior calculation and design. You want to focus on the time and the consideration that she spent choosing her weapon and the steps she took after that. Now, we're going to go through the timeline. We have the benefit of really having all of these actions captured on video. So we know that in a couple of days prior to June 3rd, Bianca Ellis had a run-in with the North Olmsted Police Department. And that's important because part of the anger that fuels her on June 3rd. You heard testimony about how she was in their jail for a night, and that she was purported to have all sorts of property and money and gift cards and other items. So when she's walking around on June 3rd, we know that's on her mind. She says as much herself. But let's walk through this timeline that we have. right? And again, you're going to have these videos, you'll have the compilation video that we went through together. But what I put together today is the kind of a streamlined timeline, all right? So you can see kind of minute by minute where she is. So at 2:36, you see her in that yellow circle. She's in her wheelchair. She's on the North Olmsted Police Department property.
How do we pay for all this? It's melting.
Oh, yeah. Looking to make it everywhere and with ED treatment from NextMD. Trusted treatment for men and women. Get started today for up to 95% off at rexmd.com/95.
Feeling a little down? Our nurses will take very good care of you. The all-new refinement at Atrox Factory. A little pick-me-up, and you'll be all better. Get your tickets online, atroxfactory.com.
A couple minutes later, here she comes into the lobby, and we meet Danielle Shook, one of the first witnesses you heard in this trial. Do you remember how their encounter went? Bianca Ellis wasn't so happy when she left the lobby. Remember, she turned the lights off as she departed the lobby. And then she kind of skips downstairs. She ditches her wheelchair and her suitcase. And you can look at the video, again, of course, see her testimony, that she walked with purpose and that she was angry. You can watch that video again that we watched here this afternoon. The careful selection of the weapon, minute by minute here. 14:55 to 2:55, less than 20 minutes after she went to the police station, she's got her weapon. $14.56, she's going to enter the Things outlet. She walks in, looks around, pay attention. She's got two knives behind her back. She's looking around. Ladies and gentlemen, she's looking for a victim. These people, they're adults. There's men in the store. Those aren't suitable victims for Bianca Ellis. She's got to find the most helpless victim she can to carry out her crime. She exits. What does she do then? Well, she's got two knives. She can't use two knives. So she's got to ditch one. She's got to pick the best one. What does she do? She taps her knives against the brick column, pitches the flimsy one, keeps the superior knife to carry out her act. Look at her walk. She's not going into that store for anything but to wreak havoc on somebody that she hasn't chosen yet. Unfortunately, or fortunately, how you want to frame it, again, it's all on video what she does that day. 2:57, there she is, knife in hand. Again, 22 minutes have passed since she went to North Olmsted for her money. And here it is. Ladies and gentlemen, this is the decision she makes after she shovels her weapon. These are the people she wants to harm. It's been decided. This is a volitional choice, ladies and gentlemen. This woman is not experiencing, and we'll get there, but this is a woman who has made decision after decision and planned this out. And finally, at 3 o'clock, you know what happened? Now, part of my job here is to make sure that you understand the elements. I'm not going to dwell on this at all, but we know that the child died. To prove that there was a death in this case, we had to show some autopsy photos. All right, I'm not even going to enlarge them on the screen here. You can see these two photographs. We know that we have a deceased victim. We also know that Margot Wood was stabbed and that she was injured, okay, for the attempted murder charges and the felonious assault. She had scarring on her body, and she will always have that scarring. So the state has met its burden as to those counts as well. This case is unique, of course, as we all know, that the burden shifts, right? The state has proved beyond a reasonable doubt all the charges against the defendant. Now, there's another step. You won't know it, and you don't have to overthink it. I know it's complex, but at the same time, you want to take it step by step and not overthink what we have to do. So what does it mean that she raised this defense? Well, we know that she has to prove something to you. Has she done that? And how can we tell? Again, I'm not going to read all this stuff. I usually don't put much writing on these slides, but because there's so much to get through, I want you to be prepared for what we want to read and talk about in deliberation. The testimony from Dr. Knopfinger is pretty fresh in our minds because he finished his testimony today. The fact that this defendant has schizophrenia does not excuse her for her conduct. So now we are talking about kind of the battle of the experts. Let's talk about Sarah West. All right, you heard from her last week. Her opinions are based almost solely off of this defendant's self-report. I don't know about you, but I got the sense from her testimony that she either hadn't watched videos or really did not remember them and did not factor into her analysis of this defendant. You'll have her report to go through. She was asked about basic things about his videos. She did not seem familiar with them whatsoever. And you've heard from Dr. Knopfinger how crucial these videos are. The timeline, the method that this defendant goes through to make her decision, Dr. Weston should not put much weight in that at all. So that's what I mean by she does not use corroborative evidence from June 3rd. But she agrees with us that June 3rd is the day we're going to focus on. We're not really talking about too much what happened before. We're going to talk a little bit about afterwards. But really, June 3rd is what we are really focusing on. Something that struck me about her testimony was that Dr. West said, I see a lot of psychosis here. And I didn't really know what she meant by that because, again, she didn't use corroborative evidence.
Without the ones like you working tirelessly to keep things running, everything would suddenly stop. No matter your industry, Grainger's here for you with professional-grade supplies. Call or click Grainger.com or just stop by. Grainger, for the ones who get it done.
O1 stated that suspect was immediately terminated after doing the surveillance. So that's what they say happened. There wasn't I'm trying to stop her from falling. No, it's saying that you threw a child to the ground. And how old is this child? All right, this was a 3-year-old to the ground.
A woman stands before Judge Board in a Texas courtroom accused of mistreating children under her care. But then the judge reviews a video of her throwing a child to the ground. What was supposed to be a simple hearing instantly turns into something far more serious. You could just feel the mood in the room shift as second that footage played, it's just pure disbelief. Judge Boyd doesn't flinch either. When it comes to kids, she's one of those judges who just sees straight through the fake tears and excuses. I don't care what her reason was. Nothing justifies doing that to a kid. Do you guys think Judge Boyd should show mercy here, or should she make an example out of her? Let's dive in here and watch.
Court is calling 2023 CR 10226 State versus Frederica Simone Nelson. So I have parties announced for the record for the state. Defense. And are you Ms. Nelson? Counsel, have you received all discovery that you reviewed with your client? Yes, ma'am. Court will find that the state is in compliance with discovery. Ms. Nelson, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Yes. Did you review the true bill of indictment with your attorney? Did you understand it? Yes. Counsel, do you waive the reading of the indictment? Yes, ma'am. State, are you proceeding on the indictment as presented? Yes, ma'am. Ms. Nelson, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with injury to a child or elderly disabled with bodily injury? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you've entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have the right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call you the right to remain silent. Did you understand by entering this plea you're giving up those rights? Yes. All right, counsel, has your client been able to provide you with any defenses? Yes. Do you believe she has a rational as well as a factual understanding of the charges against her? I do, yes. Do you believe she's currently confident with legally saying at the time of the offense? Yes. Ms. Nelson, has anyone threatened you, coerced you, or placed you in fear to get you into this plea? Mm-hmm. Anyone promised you anything other than the plea? Mm-hmm. Are you satisfied with the way you've been represented? Yes. Are you a U.S. citizen? Yes. Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? Yes. According to the plea, punishments be assessed at 4 years in the prison. There's a $1,500 fine. State recommends community supervision. There is no application for deferred adjudication, and there's to be no contact with the complainant. Did you understand that to be the plea? Yes. Defense, is that the plea? It is. State, is that the plea? Yes. Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Yes. And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are brief freestyle motions that have been filed, heard, and been determined by this court. Did you understand? Yes. Counsel, have there been any such motions? No, sir. Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There'll be 80 hours of community service restitution, anger management, MRT, CAP evaluation, and follow all recommendations. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations? Then to the offensive charge, how do you plead guilty, not guilty, or no contest?
I'm going to be honest. I don't think deferred adjudication or probation should even exist in cases like this. Some people just shouldn't get that luxury of a legal reset button. I mean, when you're capable of doing something that pretending to teach a lesson, what do you get?
But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept the evidence, takes exhibit 1 and attachments, and the court will review the same. And state, have you had any contact with the complainant? Thank you. And you may be excused. All right, as reviewing state's exhibit 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Is there anything you need to say on behalf of your client? No, sir. All right, so why are you doing this?
When I wanted to get down, instead of me pulling her and putting her down like a black hook, I could have did it first. I could have played down her.
No, that's not what it says. What you're telling me is not what's in the police report. What it says is This child came home from this early learning center. O2 stated she picked the victim up from the listed location yesterday at approximately 17:30 hours and found victim crying.